Good afternoon, everybody. Welcome to this afternoon's Law with Lunch. Sophie Watson and I are both members of the clinical negligence team, and we're going to do a talk today on care home claims. Because in my experience, these claims, even though they're not necessarily high value, are sometimes a little bit tricky from an evidential point of view, and also how to run them. So hopefully Sophie and I, for the next half an hour or so, will give you kind of a whistle-stop tour in the main points that you need to think about really when you have these claims. So I'll pass over to Sophie now so that she can do the first part of the talk.
Thank you, Anna. We'll set out there the types of topics that we're going to be covering today. Initially identifying the type of care home, which leads into which type of claim, whether it's personal injury or clinical negligence. Then looking at the initial instructions, costs implications of what type of claim it is. And then Anna's going to talk a bit about selecting the right experts and getting the best out of those experts. The first consideration to have when looking at care home claims is the type of care home. Care home is an umbrella term, realistically, for two distinct types of claim that are being brought. So you have your residential homes. Those are for individuals who need care, perhaps have issues with mobility, personal care, if they've got cognitive issues, essentially individuals who aren't able to live at home anymore. They're individuals who also don't need regular medical care, but you still may have that they have visiting medical professionals, external agencies, and perhaps there's a section within the home that may be dedicated to medical care. You also have then your nursing homes, which to juxtapose that is for individuals who do need a high level of medical intervention. And usually the people providing the care in this instance are registered nurses. So obviously, I'll come into later how that impacts a type of claim, but it's really important to get this right at the outset. So on the next slide, you'll see essentially it's whether it's going to be a personal injury claim or a clinical negligence one. So if we have the residential home, for example, it's likely that that's going to be a personal injury claim if it's a carer who's been dealing with the claimant, but we still need to obviously check that what the allegations of negligence are. So it may well be that there was a visiting professional such as a district nurse, and it might be their care that's fallen short of a reasonable standard, and accordingly it might be a clinical negligence claim. But it's good to have it at the outset, an idea of which type of home it is. Simply, the way to identify this is if you go on the care home website, have a Google search of it. Some of the websites aren't that transparent, and it may be, as I've said earlier, there are specialist divisions, different types of a residential ward, and then maybe a high level of care elsewhere. So if it's still not clear, another simple way to just ask the defendant solicitors to disclose this information pre-action. If you're a defendant in this case, you may be more alive to the types of claims that are brought and be able to flag this at the outset. And the reason I say it's important, especially if you've received a letter of notification and you realise it's slightly off with the negligence allegations, or you see this going down a route of PI when it should be clin leg or vice versa, it's well worth raising it at the outset to avoid arguments of costs occurring later on. The next slide just deals with some of the more common claims that we see in care homes. So you have your pressure sores. These usually arise out of failures to move a patient, perform skin checks, anything to do with management of particularly immobile residents. You've then got your falls. These usually obviously occur in the elderly because they've got limited mobility. Perhaps in these instances, there might not have been proper falls assessments, there's not the supervision perhaps that's required, or preventative measures to stop the individual falling implemented. And then finally, you have your delays in seeking medical attention. This may be in sort of your PI cases where the carers have not maybe taken the right observations, they've not recognised a deterioration, but it may well be that a visiting professional comes in and they've also been a delay in sort of referring them to hospital, etc. And Anna's going to deal later with some of the records that are poignant in these areas as well. Now, I promise I won't stay on this topic for too long because it is rather dry, but it is quite an important part of running these types of claims, because obviously with personal injury, and especially as I'll come to in a moment, after October 2023, the costs are going to be quite fixed and limited. So at the moment, I'm not going to obviously go through what you'll already be well versed in, which is the personal injury dependent on the value of case for incidents occurring before October 1st of October 2023. It's the standard ones we see. The only thing to note is now in the white book, this is CPR 45X. And then, of course, we have the clinical negligence. They're largely multi-track, except for the very limited instances that I've put there on the slide. Now, for incidents occurring after the 1st of October 2023, this is probably going to impact a lot of these care home claims that do fall into not necessarily making it to the multi-track, because they are much lower than 100,000. So this is where the cause of the accident is the 1st of October 2023. And it's really important to note that, because it does differ in clinical negligence, as we'll come to in a moment. This is now the new CPR 45. And really all I'll point out in this is the fast track that we were used to before now has 4 complexity bands in it. They're in 45.44 of the white book, but all I'll say on that point is, with these types of cases, if you've got one in a care home, with it being public liability, it'll fall within band 3 unless there's a reason to justify it going into a slightly higher band. But we also have this introduction of an intermediate track, and the intermediate track is for claims that are valued from 25,000 up to 100,000. And again, there's bands of complexity 1 to 4. I won't, again, go into those in masses of depth, but it's really important to have a look through those additions, because, as I say, we may well see the care home claims of those values falling within those brackets. One of the things to note as well, and this will obviously impact upon negotiations at the outset, is the stages are different in terms of what we've previously seen. So the first stage, for instance, is pre-issue up until the defence, and stage 3, for instance, is the defence up until the date set for a CMC or an order giving directions. And it's worth familiarising yourself with that when you're thinking about offers and negotiation, because if you've done a lot of work but the defence is yet to be served, it might be that if you're a claimant solicitor, you're going to want to wait until after that into the second stage to recover the costs, or vice versa. If you're the defendant, you may want to minimise that by getting in an offer early if you know it's one for settling. And there is restrictions again on the fixed recoverable costs, but you can apply retrospectively if you do have a protected party. So again, if you've got a claimant who lacks capacity, it's worth noting that. Just going to touch on the clinical negligence ones. Now, that remains the same at present. The implementations that are going to come into place deal with pre-action pre-action protocols for claims that are under values of 25,000. And at the moment, this deals with cases where the letter of notification is sent on or after the 6th of April 2024. But really what the date will be is when the Act is implemented. So we've got that date at the moment, but it's worth looking out to see when the implementations are going to come into play, because we've had the consultation on disbursements extended. So at the moment, that's the date we're looking at. Again, this is probably going to capture quite a lot of the, especially pressure sore cases, falls. One of the things to note about this is it does include fatal accidents, and again, protected parties aren't exempt. So if you've got a claimant who lacks capacity, they will fall under this. However, as I put on the slide, it may be that you can claim that bolt-on of 1,800 to cover any additional work that you may have as a result of them being a protected party. With this particular low value protocol within clinical negligence, there's 2 tracks, and to put it lightly, one is essentially if there is, so the light track, as it's at the moment called, is where there is clearly a breach. There might be an SI report indicating there's the standard of care has fallen below reasonable, and the standard track is everything else. And again, I won't go through in chapter and verse what all of the particular documents are that you need to serve with your letter of claim on that, but it is a lot more extensive than what we now commonly see. So it's all the usual information, but you've also got the medical records, expert reports, all your schedule of losses, witnesses, and the like, and then the defendant will have 6 months to respond to that. So it's very front-loaded now, or will be, once that change has been implemented. At the moment, the disbursements on that are still in consultation, but as it currently stands, council fees aren't likely to be recoverable in that pre-action phase unless it's for an approval case. So if you've got your person who lacks capacity, that can be recovered, but not generally for liability. Now, obviously, I've mentioned about it's going to get quite stringent, so it's well worth, when you get a claim, considering the documents you need at the outset, especially in the clinical negligence arena, but it is good practice in general. So coming to the next slide, when we look at the initial considerations, this is dealing with fatal accident cases, but we'll come to it on just general claims in a moment. Some of the initial points to look at is the grant of probate or letters of administration. So has somebody applied for that? Are you aware of who the executor of the will is? Of course, if they've died in intestate, you'll need those letters of administration and a note of all the fees for those applications as well. That lends also to looking at who the dependents are. So you'll have, they're obviously set out in the Fatal Accidents Act, but you've got spouses, cohabitees of over 2 years of living together who act akin to a marriage, you've children, grandchildren, etc. But that also has to be coupled with that they're getting a reasonable benefit from the continuance of the deceased life. So you're looking at financial losses there, so loss of services, or financial losses from the deceased death. So it's worth taking stock of who those dependents are at the outset. Pension information is another one that you want to get early on. This again goes to the dependency claim. So if it's that one of the dependents is relying upon the deceased's income, you need to have that information ready. Funeral costs, these just need to be reasonable ones incurred. So you're looking at the cost of your funeral service, headstones. I'm sure that everybody's well versed in this now, but wakes are usually not recoverable. But it is worth just getting all that information and then sort of siphon it down into which seems reasonable to recover. And then, of course, we've got the expenses for travel, any care provided the family. It's also worth noting any losses that might have arisen as a result of the negligence, but before the deceased's death. And then finally, just some other initial considerations before I move to Anna, stepping away from just fatal accidents. I obviously mentioned there about care claims when visiting in hospitals. We were discussing this earlier, and of course, when you're in hospital, there's going to be very limited need for somebody to care for someone because you have the doctors and nurses there. But it may be that potentially you have a case where somebody was more mobile and now not, and it's caused quite a deterioration. So that's something you may want to consider, but do also consider weighing that against the loss of the earnings of the person who's come to assist the deceased in hospital. With respect to travel costs, can be anything for travelling for the claimant for medical treatment, anything that's arisen out of the result of the negligence. Care home fees, if you've got a claimant who's in a private care home and they're paying for that, the law on that under the Consumer Rights Act is that you can there is an implied duty to perform a reasonable service, with reasonable care and skill. So if there's been a breach of that under contract law, you can get a remedy of an appropriate amount. Anna and I were discussing this prior, and it's not something that we've seen that's been recoverable. However, it's still, again, worth getting that information, and it might be something that you want to look into if there's considerable fees there. Finally, mental capacity. This is quite a big one to consider on two fronts. Firstly, obviously, capacity lends into limitation. So if you've got somebody who's got a permanent disability and always has, effectively, there isn't a limitation period. If somebody lacks capacity from the date of the when they were injured or prior to that, that's the limitation. The clock stops running essentially until they regain capacity or sadly die. If you have a claimant who has capacity at the date of the accident, this obviously doesn't prevent the time from running. So that's something you need to consider. Or if the patient does regain capacity even briefly, that's when limitation will start running again. So it's important to take stock of that. You've also got, with that paired with lack of capacity, looking at the outset of who's going to be the litigation friend, and perhaps organising somebody suitable to undertake that role, obtaining their statement, and just dealing with that at the outset. So they're just a couple of other things you might want to think. And Anna's just going to take us now through some of the further information that you might want to obtain early doors.
Thank you, Sophie. Just before we move on, just a couple of extra points on the consideration of the claim. So with the care claim in the visiting hospital, because the care claim might be relatively limited because of the fact that the majority of care is being undertaken by nurses and doctors, etc. One consideration might be whether you would be better off bringing a loss of earnings claim for the individual who's staying in hospital, in particular if they are a high earner and they've had to take a day's holiday, because that's likely to be a more valuable claim overall. With the care home fees as well, it's important to be mindful of the fact that you aren't necessarily going to recover all of the care home fees. And obviously it does depend on how long the care home fees have been incurred whilst that person is in hospital. That's something to, obviously, if you've got a significant period of time, then that might be a relatively valuable claim. But as Sophie said, in my experience, it's not something that's regularly claimed. That may be because the majority of people aren't necessarily paying for their own care home and it's local authority funded, and therefore obviously those fees would fall away. With regards to the mental capacity as well, I think it's important to really consider the mental capacity right at the outset, because just because somebody is in a care home obviously doesn't mean that they don't have mental capacity. They may have been in a care home for any number of reasons, if not just that they couldn't care for themselves. So it's important to look at whether they did have capacity and when they do have capacity after the accident as well. And we'll come on to some of the records that you might want to get to consider those aspects. So looking at the further evidence, I think the most important one to get really early doors is the care home records, really for a number of reasons. First of all, they tend to be a little bit bitty, and therefore it's likely that you're going to have to look at them and double check that you do have absolutely everything. And on the right-hand side, I've included the types of assessments that you would expect to find within those care home records. So the most regular ones that you would want to obtain are the falls risk assessment. Obviously, that's essential if it's a fall that has been the cause of the injury. Water low pressure assessment scores are also really important. They can also be important if you do have somebody who has a fall as well, because it gives you an indication potentially as to how steady they were on their feet, because it'll tell you how long they were generally sat down and whether they were at risk of pressure sores. Moving and handling assessments are obviously really important, in particular with regards to the falls. Challenging behaviour can also be a really important one, because it gives an indication as to the types of measures which might be appropriate after when you're looking at kind of the things that should have been changed to prevent, for example, a fall. And that comes hand in hand with things like a bed rail assessment. And because quite often what you'll see from medical experts, if they'll say, for example, if somebody has got dementia and they present with quite challenging behaviour, or they're quite anxious and panicky because of their condition, that having a bed rail up can actually be not a benefit to them, because if they wake up in a slightly anxious state, then they're more likely to try and climb over the bed rail and therefore sustain a fall than they would do if there wasn't one there at all. So I think it's really important that when you're looking at these assessments, first of all, that you make sure that you've got all of them. And obviously these will need to be updated on a regular basis. So it's no good having them just at the initial admission. You want to be able to demonstrate that they've been undertaken on a regular basis. And hopefully by piecing them together, you'll be able to see whether there's been a gradual deterioration in the claimant's condition, and that may affect whether he should have been reassessed and that further procedures should have been put in place or assistance should have been put in place, which may then affect your claim. The other thing to take into consideration is the medical records, and these are both the GP records and the hospital records. So first of all, if you do have somebody who it is quite difficult to assess whether they have capacity in order for limitation purposes and working out whether they need a litigation friend, this is really going to be your most cost-effective starting point to identify that capacity point. Usually, if you've got a capacity issue, you'll find that the medical records are quite revealing, because the chances are that if you're considering whether somebody has capacity or not, the chances are that some clinician along the line has also had to consider that from obviously a different perspective. And if so, they'll have usually documented that you'll see in the medical records capacity query or discussions with family members regarding capacity. So they can be a really good indication as a starting point with regards to capacity of your own client. They're also really helpful as well, because they set a timeline and they also demonstrate the condition of the claimant at that particular time. So, for example, in a delay in referring to hospital, the GP records, because often there'll be a GP that's been called out prior to any admission, can be crucial, because it'll demonstrate what was said at that particular time and how that person was presenting. And it's worth bearing them in mind, because when you're looking at the potential defendants that you might want to bring in, it might be that you're not only looking at a failure on behalf of the care home, but you may also be looking at a failure, for example, with district nurses and GPs as well. And so it's important to look at them kind of holistically when you're assessing whether there's a decent claim or not, and whether there's any merit in proceeding. So, as I said at the start when I introduced it, although these are relatively low value claims, they can be quite difficult from an evidential point of view. And the main reason for that is really due to the poor record keeping in a lot of care homes. And that's partly because of training, but partly because of time pressures and staff pressures, and potentially the amount of people that they have to deal with as well. But what you'll find is that when you look at the care home records, there's quite often gaps. And it's really important, I think, to say to your, in particular, nursing expert at the start, to make sure that when they look through, they identify any records which are missing, because you will then obviously need to go back to the care home to see if you can obtain those missing records. And most nursing experts will be quite forthcoming in saying, I would have expected to see this assessment done at this time, but I can't see it. And I don't know whether that means it hasn't been done or whether it's just simply missing from the records. It can also cause problems, however, from an evidential point of view, is improving your case. To some extent, there is, if it is not written down, it essentially didn't happen. But that can cause difficulties from an evidential point of view, from a claimant's point of view, because if it hasn't been written down, you also can't rely on it one way or another. So, for example, if you're looking at whether someone's become dehydrated and the fluid scores are erratic, or they've not been filled in with any regularity, you're going to have some difficulty in establishing that that person was dehydrated at the point of admission. The same thing with regards to falls. You know, sometimes you find that they haven't done near misses, and when somebody's kind of partially fallen, or where they haven't filled in the kind of body map to demonstrate where pressure sores have been. All of these can cause difficulties in identifying when something should have happened. The other difficulty that we're seeing coming through now is really post-COVID. So before COVID, we had difficulties because most people's loved ones weren't necessarily visiting with any significant regularity. And even if they were, they may only stay for like an hour or half an hour at a time. So there's difficulty in the evidence that they can give, because obviously there are then gaps in it. And it's an easy, the defendant can easily say, for example, well, you know, that might have been a snapshot that you saw in that half an hour, but it's not representative of how this person presented over the course of the day. So from a defendant's point of view, it's really interesting looking at the gaps in that evidence. But from a claimant's point of view, it's something to be alive when you're taking witness evidence from loved ones, especially when they can be quite passionate about the type of care that their mother or father or loved one received whilst they were in the care home. That's been even more maximised now, however, since COVID, because obviously in the COVID period, relatives weren't generally visiting in care homes. And as a consequence, we have a bit of a gap as to the evidence that can therefore be given by loved ones. So that's something to consider on both sides when you're considering the strength of the claim. With regards to the next one, proving when a bed sore developed. Now, this, in my experience in bed sore cases, is quite a tricky point to deal with in the types of litigation. So most of the time, you'll have a nursing expert that say, you know, a bed sore can develop very, very quickly over a very short period of time with relatively modest pressure if that person's not necessarily moving very much. And so the difficulty can be, especially when you have two different defendants, as to exactly when it happened. So, for example, the care home might say, well, no, that pressure sore wasn't there when X was with us. It must have happened when they were in hospital. And the hospital will say, well, this pressure sore didn't develop in hospital. It must have been occurred whilst they were in the care home. So you end up with two defendants essentially pointing the finger. And so it's really important in those types of cases to try and get a really good grasp of the timeline. So, for example, going through the nursing records with quite a lot of detail, when they have the body maps, identifying where the pressure sore was, and just double checking that we're definitely talking about the same bed sore, for example, or even making a table to show how that pressure sore is either improved or deteriorated. Because you'll see that upon examination, they should be also grading the pressure sore. So you should be able to map really that sore over a period of time. I did have a case where the compelling evidence that we had was from a family member who'd, obviously not in this capacity, but had also worked as a nurse. And therefore she had provided her relative with a significant amount of personal care and assisted in the care home. And that was really useful because it held quite a lot of weight to that evidence, and they were able to categorically say that pressure sore was not there when my relative was admitted to hospital. And that therefore meant that we were able to establish that it had occurred within hospital within really a matter of hours in accident and emergency. So it's that type of evidence and thinking maybe a little bit outside the box as to whether you can establish that when the pressure sore developed. The causation point is obviously really important in most clinical negligence cases, but it is essential really in these types of care home cases, and a lot of them will fall away on causation. So the best example I can give you of this is really in relation to the falls. You will often get nursing experts that come back and say there was a failure to do a falls risk assessment. Had they done a falls risk assessment, they would have implemented X on support upon movement. Had they done that, the fall would have been avoided. And it's really important to kind of really unpick that type of logic. So from a defendant's point of view, they're clearly going to say, well, you know, if someone's going to fall, they're going to fall. And just because somebody is within a couple of meters doesn't mean that they can prevent that fall, especially if it's occurring really out of the blue. And therefore, no amount of supervision that we were going to put in place was going to prevent this fall from occurring. From a claimant's point of view, I think that you need to be quite critical and really press your expert on these things. So, for example, the nursing expert may say, well, yes, that's correct. You know, if the fall occurs on the other side of the room, then you're not necessarily going to be able to prevent it. But having said that, the whole point of having somebody within a couple of meters is that they can kind of judge what's happening at the time and pick up any cues that that person might be able to get up, or they might be a bit wobbly on the feet, and therefore they can step in before the fall occurs. So it's important on both sides, I think, to really press experts on the causation point, because that can be make or break for the case. And I think the final difficulty is really the fact that these claims, as Sophie has already said, they really do tend to be quite low value. The PSLA doesn't tend to necessarily be huge. There's not likely to be an extensive dependency claim if it's a fatal accident. There's going to be, for example, no loss of earnings or anything like that. And the care claim may also be quite modest if they're already receiving care in any event. So that causes difficulties, in particular with regards to proportionality and the amount of evidence that you can obtain. And especially in these types of cases, even though they are low value, it's not uncommon to have, you know, 2 or 3 experts on either side. Once you've got your breach report, you might have something to demonstrate causation, and then you might have additional evidence if they've got some type of other injury which you need to either rule out or include in as part of your claim. So proportionality really plays a huge part in these claims. The reason why Sophie and I decided that we would talk about selecting the right expert is because, in my experience, selecting the right expert is really make or break for these types of claims. The expert needs to be realistic, but also needs to be quite detailed in their approach. And so that can be quite difficult to achieve. And the first thing I would say with selecting any expert is make sure that you check their CV really carefully. And this can be really crucial because what their clinical experience is can make a huge difference. So, for example, if you've got a nursing expert, you're going to have a nursing expert that has an understanding as to what it's like to work in a care home. If they've never worked in a care home, then they're not going to be able to give realistic or credible evidence as to what should have been put in place or shouldn't have been put in place. They're also potentially likely to be more critical of the notes or expect too much of the workers in a care home setting. So I think that's really important to consider right at the start as to exactly what their experience is and where the clinical practice is also based. I think whether they're still practicing is also a really important one, mainly because COVID really put a different spin on a lot of things. And in a care home, obviously, care homes were under an immense amount of pressure over COVID. And the way they operated was totally different from what they would have done pre-COVID, in particular with the amount of visiting restrictions, and also the difficulty in maybe getting extra advice from outside, for example, GPs, because of the fact that resources were so stretched. So I think it's really important when you're looking at your expert and you've got, for example, a case that did take place, whether in COVID, to think about whether they were still practicing within that COVID period. Because if they were, they're much more likely to be able to give you credible evidence as to exactly what should have happened in those circumstances. And if they weren't, it's a really easy shot for either side to be able to say, well, hang on a minute, you can't really comment on this because these were unusual and exceptional times. And in those circumstances, the judge should put limited weight on your evidence. I know this sounds daft with the last one, but whether there's any links with people in a case, the medical practitioners, it's a relatively small world and there is a degree of overlap. And I have had a number of cases where we've got kind of halfway through a case and then an expert has said, oh, actually, I'm not sure if I'm the right expert for this case because I have a link with X, and that puts us in somewhat conflict. So that's something that you might want to flag up with your expert just at the start so that you're aware. So what do you want from your expert then? So first of all, you need to have an expert that really understands that their duty is to the court, not to you. You certainly don't want a report that tells you what they think you want to know, especially in these types of cases when the case is low value. It's likely to be relatively high cost because of the amount of reports, and proportionality is going to be really important. Therefore, you really need an expert who is realistic and understands what your weaknesses are, because you need to know that for settlement. And it goes without saying, therefore, that they can make concessions where appropriate. Now, clearly, you don't want to concede all parts of your case, otherwise you wouldn't have there wouldn't be a decent expert and you wouldn't have run the case to trial. But you do need an expert to be able to tell you where your risk lies, and for them to be frank with you in conference. And I think the easiest way to do that is, even if it is low value, is you want to be able to have a conference with your expert really at the start in order to understand exactly how strong your case is and to see whether they can justify their opinions with the evidence. And in addition to that, I think that in these types of cases, it's quite easy to stray outside the bounds of expertise. So you quite often find in these types of cases that you have the nursing expert who's essentially giving causation evidence when their limitations were simply down to breach. And so it's important when you're looking at those types to make sure that you do kind of keep your expert on brief, because if they do stray outside, it's a really easy shot for the defendant, or if you're for the defendant, for the claimant, to criticize and undermine your expert. So I included this quote just because I thought that it was a really good summary of exactly what you want your expert to be. So you need them to be authoritative. So they need to be able to speak clearly, obviously, and authoritatively on their area of expertise. But you want them to be cautious, thoughtful, and well-balanced. In my experience, the best experts are the ones that are able to say to you, look, I think that you've got a good case because of X, Y, and Z. But if I was for the other side, I would be arguing this, that, and whatever. Because that gives you a good understanding that they can see it from two sides of the coin, as we can as lawyers. And that means that they've given some thought to the other side's arguments as well. And if they've given thought to them and can still dismiss them, then you can be fairly confident that you've got a good expert who's going to hold up well in court. So when you're looking at the report, you need to be going through it, first of all, checking whether it complies with the requirements of Part 35. So I had a recent medical expert tell me that they had been to court, and when they had got into cross-examination, the expert on the other side had been asked about his CV. And when he was asked about his CV, the way his CV had been framed was that essentially that he was hired by the defendants to defend claims in the NHS. And as a consequence, that completely eradicated his credibility and meant that the judge felt that potentially he was biased. So it's really important to consider things like that and going through expert CVs, because that was a matter of a couple of words and probably not really intended to be taken like that. But as you can see, it completely undermines an expert's case. You need to obviously check that the report is accurate. So going through and checking that the chronology is accurate, that it reflects actually what happened. And that can be really important where in order to make sure that you've got all the medical records. And obviously, if you haven't got the medical records, you need to get them, and then obviously update the accuracy of that report if you need to. Checking whether it's easy to follow and understand is obviously really important. In my experience, if you as lawyers are struggling to understand it, then the judge is just a lawyer. They don't have any necessarily any further expertise in clinical negligence than you do. And in fact, you might have more expertise in clinical negligence than the judge does if they don't regularly sit in clinical negligence cases. So as a consequence, if you are not understanding the report, the judge is also not going to understand the report. And if the judge doesn't understand the report, they're not going to be able to find for you. So it's really important to make sure that you really press an expert, because something that can be obvious to them isn't necessarily obvious to us. And making sure that it's kind of free from legal jargon. The worst reports are when you read and every other word you feel like you've got to Google it in order to identify what was happening in the medical report. So little things like that can make a really big difference as to whether your expert evidence is going to be accepted or not. We touched upon this before about whether they're sticking within their expertise. It's a really easy own goal if they haven't done that and it's picked up in cross-examination. And also including any literature that they rely upon and making sure that's included in their report. And that's something in conference to really make sure that you are focusing in on. So, for example, if you do have an expert that says, this is my opinion and this is based on research, you want to know what research, can it be included as part of the report? Because if it's just their own experience as opposed to, for example, based on a paper or guidelines or anything, then it's going to make it more vulnerable to challenge from the other side. Because an expert, just because an expert doesn't do something one way doesn't necessarily mean that falls within the remit of negligence, because there could be another practitioner who could do it a different way. They may not agree, but it's equally valid. So we've covered some of this about conference, focusing really on what the breaches are and duty. Early doors is really important because, as Sophie said, certainly with the new legal regime coming in, there's a focus on front-loading cases, and having a good understanding of your case early doors then makes it easier going through. And it's important to be able to really nail what the breaches of duty are, because, as I said earlier, causation in these types of cases is problematic. So working out what the breach of duty, what causation flowed from that, and then what the result is almost essential to winning these types of cases. And in my experience, sometimes with nursing reports, you can have many breaches of duty, not all of which are causally relevant. So, for example, the failure to update a falls risk assessment may well be a breach of duty, but if it didn't change that person falling, then it's really irrelevant. So working out what they are, what causation matches up to them, and then only pleading your best points is going to be absolutely essential in presenting a good case, which is going to be taken seriously by the other side. Understanding experts' reasoning, as we said, is obviously crucial. Checking that they followed the correct legal tasks, again, as we've just spoken about, making sure that they haven't just relied upon their own expertise as a kind of a standard for negligence. And it gives a good chance, an opportunity to see how they would present in court, but also an opportunity for you to say to the expert, okay, so we've been through all of these breaches of duty. We've worked out that 5 of them aren't causally relevant, and so we're just going to rely upon these 3 breaches of duty and causation points. Do you agree? And then you can obviously go ahead and plead them either in the letter of claim or the pleadings. So in summary, and I'm sure Sophie will chip in if she has anything to add, the most important take-home point is really identifying early doors, whether it's a nursing or residential home, because that will dictate the standard of care, but also the amount of costs which are potentially recoverable, because it will dictate whether it's a PI or a clin neg claim. Early disclosure of the medical records and the nursing records in order to identify what your breaches of duty are. value the claim early so you have a good understanding of proportionality, and your selection of your expert is going to be absolutely crucial to the success of the case. Okay, thank you very much. If anyone's got any questions, then obviously feel free to email as well.